Yeah, I mean, like I think there's a lot of people who would who may agree with you on that, but at the same time, there was a recent ruling actually out of Montgomery County, Maryland, up near where I live. I'm in Virginia, Northern Virginia, and the judge in that case, found that their sensitive places restrictions were okay, even though that county was almost entirely blocked off from legal carry, even if you have a permit, just like Maui. But your judge, in your case, who, by the way, was this is an Obama appointee, correct?
Yes, Judge Leslie Kobayashi.
Mm-hmm. And she found the opposite, right? She came to the opposite conclusion of the judge in the Montgomery County case, even though they're both appointed by Obama, is my understanding, if I'm remembering this correctly. And you've managed to convince your judge that, this 96% or these sweeping gun-free zones don't comport with the Second Amendment, essentially. What was it essentially in that reason? Because she does talk about this recent ruling in Montgomery County, but disagrees with it, comes to a different conclusion. What was her logic laid out there?
Well, just as an aside, I'm saying 96% as for just to illustrate the point of how harsh it is. I don't want any of the viewers to think that that's somehow a magic number. I mean, this could be 50%, sure. Right? But that's
but it's in line with what a lot of these other
yes.
Jurisdictions that have passed this rule you're talking about, the default rule or the vampire rule, some people call it, where they've switched the understanding that most basically everywhere has always had about gun carry, which is that it's all right inside of publicly accessible private property, so a storefront or a restaurant or something like that, unless the owner posts a sign saying that it's you're not allowed to carry a gun. They flipped that assumption around so that now all publicly accessible private property is off limits to gun carry unless the owner posts a sign saying you can carry, which obviously has this huge effect that you're describing with these percentages, right? That
yes,
most places become off limits. I think in New York, the governor described it as when she was asked where you'd be legal to carry, she said some roads. And it sounds like that's basically the same situation that you ran into.
Effectively, roads and sidewalks are where you can carry in the state of Hawaii. And, what our judge did is simply apply precedent. I mean, and that's something that the Maryland court did not do. Under Bruen, the burden is on the government. Once you have said you want to engage in protected conduct, in this case, carry a gun, the Supreme Court was very clear. The burden is on the government to affirmatively prove that that there's a historical tradition of banning a carry in these locations. And that bottom line is just simply wasn't done by the state of Hawaii. And the reason they couldn't do it was because there simply isn't any historical tradition of banning carry, say, at a beach or a park. And we showed, the judge acknowledged that I produced evidence that banks have been around since the time of the founding. I mean, there have been banks for thousands of years. I mean, at the founding era, I mean, there were banks in at least New York and Massachusetts, several other states, had banks, and there were no restrictions by the government. Now, there may have been restrictions by the bank itself. That's a whole different kettle of worms. And the state of Hawaii attempted to simply rely on laws that restricted carry in markets and fairs. But here's the interesting thing.
Right. They said that was somehow similar to banks.
Yes. But these laws, I looked at these laws, and it turned out that they didn't actually ban carry in markets and fairs even. There are only two supports for banks were bans on carry in a threatening manner. And I don't think that they won any favor there by relying upon laws. And honestly, I mean, I think misrepresenting the laws initially until I pointed out and looked it up myself. But I mean, that's all that happened, though, is our judge faithfully applied precedent. And that's in line with what's been done by
Well,
the court in Antioch. I'm sorry, go ahead.
no, yeah. One of the more interesting provisions, though, in this ruling to me, because I think it extends well beyond Hawaii itself, right? Some of these things extend to the other states that have tried to pass these post-Bruen response bills that have these sort of novel provisions, like you're describing there, the default swap provision, where or banning guns in banks or at all sorts of different venues. But there was one provision in this bill that I think is fairly popular in a lot of states, which is restaurants that serve alcohol. States handle this differently, but it's not uncommon for them to just ban you from carrying in at all in an establishment that sells alcohol. Some of them do, like, if it's more than 50% of their business comes from selling alcohol, they try to make essentially bars and taverns off limits, while other restaurants that serve alcohol are allowed for carry. But this is something that's not as much of an outlier as some of these other provisions, and yet the judge found that there wasn't historical support for that. Can you walk us through that section of the ruling?
Yeah, I mean, something that's important here is it's not just restaurants and bars that serve alcohol; it's their parking lots. And a big problem with this law is, my clients like to go to Maui Mall. Maui Mall has, dozens of different businesses. One of them is, O'Reilly Auto Parts place. One of my clients frequent. He is not allowed to carry when he goes to O'Reilly's, because there's 2 restaurants in Maui Mall that share a parking lot with O'Reilly that do not allow, and because of that, you can't carry in any of these businesses. I mean, that doesn't make sense. But I mean, ultimately, though, I mean, to get to the underlining point that you're asking about is whether or not there may be historical tradition of making people who are actually drunk, that have been drinking, not allowing them to carry. But at the colonial era, there was absolutely no laws that said you can't go to a restaurant that happens to have alcohol and carry a firearm, as long as you're not drinking. And, or at least, and the reality here is the state wasn't able to produce any evidence, that either at the founding or at the Reconstruction time, a person couldn't get himself a steak at the local pub, eat it while carrying. And that's what they were required to do. So while it may be that there are more laws impacted, because in the 20th and 21st century, it's become a little more of a tradition to more states have allowed these types of bans, doesn't impact the analysis. So what we look at is the founding era.
But it has implications for those other states potentially.
Oh, sure. Absolutely it does.